Welcome, everybody, to our fifth webinar in the Canadian Trademarks series. My name is Christian Bolduc. I'm a principal at Smart & Biggar, and together with my colleague Francesca Roy, we're going to talk to you today about the very, well-known topic now of Bill 96 and the changes to the Charter of the French language. But before we do so, we have a couple of housekeeping matters. So the presentation will last about 45 minutes. It's going to be followed by a Q&A session. Send your questions as we present, and depending on the questions, we may actually stop at one point and address your questions. So please do not wait until the end to do so. Use the Q&A button or section at the bottom of the screen to send your question rather than the chat. The presentation is going to be recorded, so those of you who want to see it again obviously can do so at their leisure, or those who cannot will be able to do so. At the end of the webinar, please complete the survey. You're going to have a pop-up that will appear, and that would be greatly appreciated. Your feedback is taken into consideration for the preparation of next year's series of webinars. So with no further delay, we're going to kick this off. So again, those are your two presenters today. I believe you know about Smart & Biggar, so we're across the country. This is what we will be covering today. Of course, we would have loved to have regulations to be able to provide more guidance than we will be able to today. We were expecting those earlier this year, but they have yet to come. But we will do our best to provide guidance, nevertheless, on the things we've learned since the coming into force of Bill 96 last year. So among the things that we have learned in the last year is Bill 96 has been very useful because it has actually put the Charter of the French language back on the list of items that businesses that sell their products or services in Canada, including in Quebec, need to be aware of. Its status has been adopted almost 50 years ago to protect the French language in all spheres of public life. So we're going to go through this fairly quickly because we've covered this before, but we thought it'd be important to cover the basics again. So Bill 96 itself was sanctioned last year on June 1st. It introduced a number of changes to the Charter of the French language, including the right to live in French. There's major revisions impacting, work, education, business, commerce, including contracts and courts. The complaint process has been revised. The Office québécois de la langue française, the OQLF as we call it, has increased powers. The fines have been increased. And there's even a clawback on the trademark exception, which is something that we'll discuss fairly extensively today. That is that last bit that we're expecting. We are still expecting guidance in the form of regulation from the Quebec government. So again, just for those who don't know, Quebec is a province in Canada. It appears here in red. So the language of commerce and business is going to be our focus today. So as you can see from these images, it concerns products, it concerns promotional material, website and the like, and advertisement and store signage. I will now turn it to Francesca to go over the rules as they exist and have existed for a long time.
Yes.
so as to provide the necessary background for the rest of our presentation.
Yes, thank you, Christian. So, as Christian was saying before, diving into Bill 96, we thought it would be important to briefly review the current general rules so that everybody is on the same page. So the general rule for markings on product, including their container, packaging, their labels, any documentation that is supplied with it, is that they must be in French or in French and another language, provided that the inscriptions in another language are not given greater prominence than the ones in French, or be available on more favorable terms. So in practice, the no greater prominence requirement for any inscription that is not in French will be assessed in terms of general visual impact. So of course, in terms of the size of the lettering, but it could also be according to their position, their font, or even their color. As for the available on terms as favorable requirement, think, for example, of a user manual that would be included in a packaging, but that would be only available in English with a QR code redirecting the consumer to the French version available online only. So, of course, that type of documentation would most likely not comply with this requirement. For commercial publication now, the general rule is the same. They must be in French or in French and another language, provided that the other language is not given greater prominence than the French, or be available on more favorable terms. What is important to note here is that commercial publications include websites and social media pages. So even if a company has no physical place of business in Quebec, if its website proposes content aiming at carrying out commercial activities in Quebec, or specifically targeting the Quebec consumers, it must be available in French. For public signage and advertising, the rule is that any message displayed in a place accessible to the public, regardless of the medium that is used, must be in French, or in certain cases in French and another language, provided that French is markedly predominant. The markedly predominant requirement means that the text in French must have a greater visual impact than the text in any other language. So, for example, if you have a text in French and in English, for instance, on separate signs, the French inscriptions must be at least twice as large as the English inscriptions. If the inscription appear on separate signs, those in French must be twice as numerous as those in the other language. And Christian, back to you.
Thank you, Francesca. So now to the recognized trademark exception. So the rules are pretty clear. You need to use French in Quebec, and sometimes you can use another language together with French, using the teachings that Francesca just delivered to you. Now, to that, there is an exception, and that one is the trademark exception. So what is it exactly? So the trademark exception is essentially that if you have a recognized trademark, it doesn't need to be translated into French, provided that no French version of the trademark has been previously registered in Canada. So the first takeaway message for today is, going forward, if you have done that in the past, do not register a French version of your trademark, even if from a trademark perspective, it's obviously very valuable. From a point of view of managing what you're going to be putting on your products and services in Quebec, it may, warrant not to register the French version of your trademark. So move to the next slide. So what's a recognized trademark currently? So a recognized trademark currently is a registered trademark. So it's a trademark for which a certificate of registration has been issued by our Canadian Intellectual Property Office. It is not a pending application. And I know in the past, sometimes inspectors at the Office québécois de la langue française have accepted, proof of a pending application, but I believe they were told that this is not acceptable. It's got to be a registration. Now, we'll talk about this a little bit later in further details, actually, what needs to be registered. The benefits is that if you have a registration, all you need to do after you receive a complaint that tells you this term or this expression that corresponds to your trademark needs to be translated into French, you send to the inspector your certificate of registration, and that ends matters there. So it doesn't go any further. The file should be closed. If, however, you want to rely on the common law trademark, then you have to prove that you have common law rights in Canada to the point that your mark is known and has some level of recognition in the market. The inspector at the OQLF is not trained, is probably not a lawyer, and that person is not equipped to judge or assess this type of evidence. So it used to be that in those cases, the OQLF and the inspector would turn the file to essentially to be processed and to be, I would say, judged in court, essentially in the context of penal proceedings. Now, this is probably now a bit different in the sense that the process at the OQLF level has changed. And, we're waiting for confirmation as to exactly how this would pan out. But what remains is that inspectors are not able to decide to determine or assess this type of evidence, and it's going to have to be done in front of a tribunal, be it the Cour du Québec as it used to be, or an administrative tribunal that reviews the decisions of the OQLF in matters such as those of the French Charter. Of course, relying on common law trademark rights is limited and also somehow burdensome for the reasons that we just discussed. So the way the process goes at the OQLF, just to give you an idea, is a complaint is formulated by typically a consumer or a disgruntled employee or a competitor, whatever. There's an investigation that's being carried out. If the OQLF finds that the case warrants that it intervene, it will send a letter to the offender. Then you're given an opportunity as an offender, you have an opportunity to engage in a dialogue with the OQLF and, either say that you're going to remedy the situation or that you believe that the situation does not need to be remedied because, for example, you have either a certificate of registration, which would end the file there, or you want to rely on common law rights. And if you do so, then the file is going to have to be moved to another stage of the process where you're going to be in front of a tribunal and you're going to have to prove your common law rights. And if you fail to do so, then you're going to have a decision rendered against you with orders and potentially fines and penalties. So that's the process if you decide to rely on common law rights. In addition to this, and we're going to be talking about that a little bit later, is that the common law rights are going to be eliminated in a year and a half from now. So we'll discuss that in a few minutes. The other aspect of the recognized trademark exception, when you look, for example, at outside signs where you do have a registered trademark, in the case of this example is Very Good Books, there was a slight clawback on the trademark exception about 7 years ago. And what the OQLF did at the time, the Quebec legislator, is that said, you don't have to translate your trademark in those type of circumstances, but you need to have a sufficient presence of French that is visible in the same visual plane as the store sign, for example, outside the store or in a mall, for example, so that consumers know what is going on in that business. So that's the sufficient presence of French. So it's easy. You just add descriptive language, a slogan, or an indication as to the nature of the business. And that does the trick. And it will continue to do the trick for another year and a half. Now we're going to talk about Bill 96 and the clawback on the recognized trademark exception. So I'm going to turn it back to you, Francesca.
Thank you, Christian. So Bill 96 significantly modifies the recognized trademark exception. For markings on product, as of June 1st, 2025, the exception will be restricted to registered trademarks only, provided that no French version has been registered. So there will be no more common law rights available. In addition, if a registered trademarks includes a generic term or a descriptive of the product in a language that is other than French, this generic term or description will need to be translated into French and will need to appear on the product itself or on a medium permanently attached to the product. So, as we have said a couple of times over the past few months, and as Christian reiterates at the beginning of this webinar, we are still awaiting clarification on the scope of this new requirement. At present, the only insight that we have on how generic terms or description of products will be construed by the OQLF and ultimately by the Quebec courts is the comments that were made during the commission tasked with reviewing Bill 96. So the label that we give here as an example is very analogous to the trademark that was discussed during the debates to justify the introduction of the new section 51.1. According to what has been said, if that green label as a whole, so as a unique graphic component, including all the words that you see into the circle, so if that label were to be registered as a trademark in Canada, all the words except for the trademark Aphrodite would need to be translated into French, as they would clearly be considered descriptive or generic. So even the 100% recycled plastic, of course, hand soap, green apple and pear, all of these English wordings would need to appear on the product in French or on a medium permanently attached to it. So in other words, it seems like Section 51.1 was specifically created to prevent businesses from relying on the trademark exception to avoid having to translate into French terms that are solely meant to inform the consumer about the product itself, its characteristic or its features. We will see on the next slide what our green label would look like as of June 1st, 2025. So we can see it's a bit crowded. Of course, there are other outstanding issues with this upcoming requirement. For example, does the restriction apply to markings on product only? So currently, as I was saying earlier, the general rule applies to a product, to its container, to documentation that is supplied with it, whereas the new upcoming section 51.1 applies to product only or mentions product only. So of course, it would be curious to allow businesses to reproduce non-French registered trademarks on their product, but not on the packaging. Hopefully, this will be clarified. Also, we have no guidance at this time as to what qualifies as a medium permanently attached to the product, and there is no certainty at this time that the no greater prominence requirement will also apply to the French translations of generic and descriptive terms.
Perhaps one comment, if you allow me,
Of
Francesca,
course.
on the medium permanently attached to the product. When we asked about whether or not it needed to be there at the time consumers were purchasing the product, for example, on the box.
Yeah.
And then, of course, when you remove the product from the box in use at home, it no longer appears there. And that was considered not to be satisfactory in our discussion with the representative of the OQLF. Of course, the OQLF is not bound by what the people working there say, but we thought that we would share this information with you.
Thanks. Now, for public sign and commercial advertising. So as of June 1st, 2025, again, the exception will be restricted to registered trademarks, also provided that no French equivalent is registered. But Bill 96 introduces an important other modification. So with the coming into force of Section 58.1 of the French Charter, any non-French registered trademarks appearing on a sign that is visible from outside premises will be allowed, provided that French is markedly predominant on the sign itself. So as we said earlier, markedly predominant means twice as large. Whereas currently, under the French Charter's regulation, the only limitation to the exception for public signage and commercial advertising pertains to non-French trademarks that are displayed outside and immovable. So if we look at the difference, if you can go to the next slide, please, Christian. So the difference between outside and immovable and outside premises is quite important, especially if we look at the definition of these words, which is provided under the regulation respecting the language of commerce and business. So as we can see, immovable essentially is defined as a building, whereas premises means a space that is closed or not, devoted to an activity, in particular a stand or counter intended for the sale of products in a mall. What is important to note here is that on its face, the upcoming section 58.1 seemed to apply only to premises inside a building and not to the buildings themselves. So the question here is, was it intended that 58.1 also applies to recognized trademark that are displayed outside a building? It is not clear at the moment, and of course, we expect this to be addressed in the upcoming regulations. Now, if we look at the difference between the current requirement and the upcoming requirement, with an example, which is signs on stores inside a shopping mall, under the sufficient presence of French, descriptive language such as librairie for a bookstore or meubles et électroménagers, which means furniture and appliances, in less prominent lettering than the English trademarks would be acceptable. The French inscriptions could also appear nearby the sign on which the English marks appear, of course, provided that they are in the same visual plane as the sign and with the same visibility as the trademark. It could have been, for example, in the store window. And if we look now, if we compare what the same example would look like under the markedly predominant requirement. So the same signs in a shopping mall would need to include French inscriptions that are twice as large as the English trademarks. Also, the French inscriptions would need to appear on the sign itself. And finally, Bill 96 is silent as to whether the new restricted recognized trademark exception will apply to commercial publications. In our view, it is safe to assume that it will, and to prepare accordingly if you are currently using non-French trademarks on commercial publications and especially on your websites.
Thank you, Francesca. It looks like we have a few questions here. So before we move to the next slide, we will try to address these questions. So one question is about the nature of the clarification that will be coming from the legislator. What we're expecting right now and have been expecting for quite a long time now are regulations. So there are already regulations in place in Quebec. It's the regulation on the language of commerce and business. We're expecting amendments to those regulations that will come and provide guidance on both 51.1 and 58.1. We were expecting those, as I said earlier, in the summer, late August and late September. Now we're at the midpoint in November, and we still have not heard back from them. So hopefully we will by the end of the year, but as soon as we do, please do know that we will communicate our comments to all of you through our usual publications. I have another question here that talks about how does this affect secondary or shelf packaging, corrugate displays. So all of this is covered by the general rule, which is everything has to be in French or in French together with potentially English, so long as the French is at least equally prominent as the English. On those type of, I would say, supports, we're not talking about the product itself, right? So if we're not talking about the product itself, then 51.1 should not apply unless we're talking about the container within which the product is found in a normal purchasing situation. We have to remind ourselves that the folks at the OQLF are not trademark trained, and when they consider what a product is, for example, in the example that Francesca used, a soap, the product is what is inside the bottle. It's the soap. But for normal consumers, it's the actual bottle of soap that they purchase, and that is the product. So that's what the OQLF and legislators' point of view probably are, notwithstanding the fact that Section 51 talks about products, packaging, and containers, and 51.1 does not. Hopefully, the guidance that we're going to get also will address that. We also have another question here that is asking us what generic terms in the mark itself will need to be translated. And they use the example of soft soap, for example. And soft soap was an example that was used during the debate of the commission that Francesca referred to earlier. And the then minister of the French language had no issue whatsoever with soft soap. That's in his mind, that was a recognized brand, didn't need to be translated in whole or in part, even though the soap component of soft soap perhaps is what is inside the bottle that was shown during those debates. There's other examples that we can think about. And of course, as long as those examples are recognized brands that have been around for a long time, I suspect that those will not be targeted by the OQLF in the context of 51.1. Of course, we can't provide certainty at this point in time, but you know, based on what we've heard, the discussions we've had with the UQLF and the Minister of the French language over the last year, that is where it seems to be going in terms of interpretation, i.e., an interpretation that will be narrower than the one we would have under trademark law. For example, descriptive will be probably construed a lot more narrowly under the regulations that will be published than they are under trademark law. They also have to be very clear and not subject to interpretation for the same reason that we've mentioned earlier. The folks at the UQLF are not trademark trained. And so it needs to be set in a language that is very clear and easy to apply for people who are not lawyers or trademark trained. I believe we have a couple of other questions. In fact, many other questions. So please do keep them coming. We have a question here for websites. Can we infer their language preference based on browsing history, past purchases, or where they previously transacted, or must the consumer be allowed to select language regardless of how they shopped in the past? You want to address this one, Francesca, or you want me to tackle this one?
Go ahead. That's a good question.
So I would say that in my mind, the purchasing history or the visiting history of consumers will have most likely no bearing. Yes, it is a great question, but I think that based on the principles that Francesca explained, which is it has to be available in terms that are as advantageous as the other version. And that should not depend on the history of visits of a consumers or of consumers to the site. So when you go on the site, you should have the option of selecting French or English when you are based in Quebec. And that should be not complicated, easily done, and obvious. So hopefully that answers your question.
I mean, you can have two different versions of the same website, one in
Yeah.
English and one in French.
So that's kind of what I was saying, picking the one
Yep.
up, so toggling between the two versions. So thank you for the clarification. Now, somebody's saying, yeah, well, websites from all over the world are accessible in Quebec. How do you know whether your website needs to be compliant with the French charter? Can we assume the owners of such website do not need to comply if the goods and services are not offered in Quebec? You want to tackle this one, Francesca?
Yes, as I was saying, if the website specifically targets the Quebec consumer, you can assume that it has to be available in French. Now, there might be gray areas, but if on your website you a Quebec purchaser can select products, can see where the Quebec the distributors are in Quebec, we can assume that the site would have to be compliant with the French charter.
But if it says that they do not ship to Canada, I think that settles the question, right?
Right,
That
I
would
agree.
be more. That would be more in the black and white category, or not in the gray one. So we have many other questions, but before we move to those
Many other
questions,
slides.
we do have many other slides. So please bear with us for a minute. We're going to try to go back to your question as we move in our presentation. So let me move to the next slide here. All right, so questions have been raised about federally regulated entities. There was some, I would say, questions about whether or not they had to be compliant with the charter in the past. Well, since June of last year, 89.1 makes that pretty obvious that they need to be compliant if they are in Quebec. There's also something else that was added to the French Charter, as we mentioned earlier. It's the right to live in French and be informed and served in French. This not only brought amendments to the Charter of the French language, but it also brought amendments to the Charter of Human Rights and Freedom, which is a piece of super legislation that we have in the province of Quebec. So what does that do? It essentially provides a right of action to Quebec consumers that could be used by them to launch a class action against businesses that do not comply with the French Charter. So it's essentially a route that consumers can take without going to the OQLF for remedying a situation that, in their view, is problematic. So consumers can actually turn to the tribunals directly for correcting a situation that they feel is impeding their right to live and be informed in French in the province of Quebec. Now, this is something that was extremely worrisome when this came out. We've checked recently, so unless Francesca corrects me, and something popped in the last couple of days. To this day, after almost a year and a half, no such class action has been launched in Quebec to our knowledge. So we do not know if that is going to remain this way, but that's something that people need to be aware of. How to prepare, and perhaps that's going to address some of the questions that we have waiting there, and there's many of them.
Most certainly.
Now, current delays for examination at CIPO, as of the 1st of November, we're looking at more than 4 years for applications not using the pre-approved goods from the Goods and Services Manual. I was at a meeting of the Director General of the Trademarks Office yesterday, and we were told that the situation will get a little bit worse before it actually improves. It's going to get a little bit worse until we get to the spring of next year. And then it's going to get a lot better quickly because the office has hired 105 new examiners that are going to begin very shortly and that are going to be fully operational in the spring of next year. So we're looking at a doubling of the number of examiners in the next couple of months. So hopefully this will address the delays at the trademarks office. Now, obtaining a registration to comply with the French Charter, it is not a valid reason for accelerating examination of an application. It's been asked, and the answer was no. So forget that one. So of course, you could decide, like some businesses have done in the past in Quebec, to translate your trademark rights. But if you're your trademarks, but if you're a business that's operating on a global scale and you have never translated your trademarks anywhere, doing so in Quebec perhaps could impact your trademark rights. So maybe other options need to be considered. All right, so of course, the easiest way of dealing with this, to the extent that it is possible, is to register your trademarks. Now, not everything need and should be registered. There are trademarks that are not going to be considered registrable by the Trademarks Office. In cases like that, what you should seriously consider is actually translating those trademarks when you do business in the province of Quebec. Now, turning to those trademarks that are registrable, that have value as trademarks, and therefore that should be registered, bear in mind that the OQLF is not the Trademarks Office, it's not the Federal Court of Canada, And when we're saying that your mark needs to be registered, it doesn't need to be registered with the goods or services that you're currently offering in the province of Quebec. It just needs to be registered. So when you're trying to get a registration, notably to avoid having to translate your trademark in the province of Quebec, and you have a long shopping list of 5 pages of goods and services, please consider whether you should instead eliminate some of those goods and services and focus only on those that are in the goods and services manual and get that mark registered more rapidly. Right now, the delay of examination of application that only contain goods and services from the goods and services manual it's actually a little bit shorter than 20 months. It's hovering between 18 and 20 months. And for comparison, a Madrid application is examined at 15 months currently. So it's almost matching the delay of a Madrid application. So if you're using goods and services from the manual, only goods and services from the manual, that's a good way of getting a registration quickly. Now, you could also request expedited prosecution in circumstances where you have a situation, an enforcement situation to deal with, online marketplace, custom, and in the market using the traditional system, i.e. the courts. Now, what happens if you don't get a registration by June 1st, 2025? Is this the Armageddon scenario that this image seems to be invoking? Well, we're going to look at the the more dramatic side of things, then we're going to get into the more practical side of things in a couple of minutes. So yes, the fines have increased significantly. They also double for a second offense. If it continues for longer than 1 day, each day is going to be considered a separate offense, so it's going to add up pretty quickly. The OQLF has greater enforcement power, and it can issue order that if you don't comply with, they can turn to the court and turn these orders into injunctions. And there's obviously the reputational risk, which is never a good thing to have in Quebec. Now, in terms of being practical about this, bear in mind that the purpose of the OQLF is not to punish, but to educate. And so usually, and we've been reassured that this will remain the approach of the OQLF, and you're going to see the statistics in a couple of minutes, seem to be confirming that. So the statistics from last year to this year indicate that their average cases that are settled remains at 85%. So it's only a handful of cases every year that make it to court. So to the extent that you show willingness to address a situation, there is no reason to believe that you cannot find a compromise that will be acceptable to the OQLF. Of course, it has to be reasonable, and it may include phase-out periods, and that could be a couple of months long, depending on the task at hand. If, of course, a situation results from outside forces that are beyond your control, for example, you're waiting for approval from a city to change the signage outside your building, then they're going to understand and they will be reasonable. Now, in terms of statistics, you see that there's been a significant bump in complaints in 2021, and it has continued to increase in 2022. This trend will probably continue to go up. What is also interesting to see is that in past years, the number of case closed and complaints were almost equal, Now, it seems that the OQLF is building a backlog, not necessarily as bad as our trademarks office, but there is a backlog right there that is clearly showing. Last year was pretty bad. It's still pretty significant this year. We'll see if that continues. So what does that tell you? It says that essentially between the time that a complaint is filed and the time that the complaint is processed, i.e. investigated and acted upon, there might be a significant delay. So that could be the delay that you need to get your mark registered. Now, in terms of what is the subject of the complaints, this is very, very revealing. And it seems to be showing a clear trend that commercial publication, websites, social media, and the like are the targets of the vast majority, almost 50% of the complaints are there. And then public sign and commercial advertising next. And lastly, between 5 and 10% of the complaints are the products themselves and the packaging. So that gives you an idea of what is the center of attention here and what is pushing consumers to file complaints the most. Social media, websites, and outside signage, more than products themselves. Now, this is very small, and we apologize for that, but the fines from last year were not in any way greater than they were before, but do bear in mind that those fines were ordered in cases that were filed, most likely in 2020 and 2021, because the pendency in court before a case is heard is about 2 years. Still, I think that it indicates that the trend is still on the lower side of the fines. Now, what can you do to make your life easier and to prepare? Of course, review your portfolio, taking into consideration the guidance that Francesca has provided to you as to, what was the example that was given during the debates of the commission tasked with reviewing the bill? And what we've indicated also today, you go over your portfolio, and if you do have registration for entire labels that include terminology that is either clearly generic or clearly descriptive in the same sense as what we've been discussing today, then address those immediately. For those that are more a question mark, then our recommendation is, to the extent that you can wait until we do get these regulations that we're looking for in the coming weeks or months. Now, trust us, we're pushing hard on those folks to deliver the legislation and the guidance, but we are at their mercy. Now, I was told earlier this week that what would help a lot is if individually we were to write, or through our associations, if we were to write to the Minister of Economy, Mr. Fitzgibbon, to explain to Mr. Fitzgibbon how important it is for us to get those regulations for guidance and to prepare to ensure that we as businesses can comply with the Charter of the French language and those changes that will come into force in a year and a half from now. Now, if a complaint is filed, you have to think now about how that goes. So how long does it take you to replace your labels and your packaging? What's your phase-out period? What's the product life once it's put in the market? So if you tell us, well, I can put a product in the market now and it will still be in the market a year and a half from now, well, you're going to have to start addressing those changes now, because it's what's in the market in a year and a half from now that's going to be the subject of the charter, not what is introduced in the market a year and a half from now. So if the lifetime of a product before it actually purchased can go up to a year, that's something you need to take into consideration. Now, the phase out period, if it's a couple of months, then that's something that you could negotiate with the OQLF if your marks have not proceeded or matured to registration in time, negotiate with them for a phase out potentially. And while you're negotiating this, if your registrations issue, then you have the solution to your problem. Of course, each case is going to be different from the others, and they need to be looked at separately, one from the other. But I think those are things that you need to consider. Of course, for a signage outside premises, as Francesca has mentioned, is it going to be only inside the malls that are going to be targeted, or it's going to also be outside buildings? I mean, this is a pretty significant difference. There's so much those folks can do with the regulations, but they can definitely change the definition of premises to mean that going forward, it means a building. Who knows what they can do? Remember, the definitions that Francesca mentioned are in the regulation and they can easily be changed. So we're going to have to wait to know what will happen with that. We did make it clear to them that if the purpose of that is only to change the signage inside shopping malls, for example, well, it's going to look a little bit like the image that Francesca showed you. We're going to see boutique, boutique, boutique in huge letters like this, and the brands are going to appear tiny next to them. That doesn't make a lot of sense. So those are things that were conveyed to the Quebec legislator, and hopefully we're going to get somewhere somehow with that. Now, assume that the trademark exception that is restricted only to registered trademark is going to also apply to commercial publications, as Francesca probably mentioned. Now we're going to turn to the actual questions. We still have a few minutes ahead of us.
That was a lot to cover.
Yes. So somebody's talking about marketing videos, voiceovers. Do we need to have a French version, or would subtitles be sufficient? Now, are subtitles something that you, Francesca, would be considering to be on as favorable terms as the English version?
I would not, no.
Well, neither would I. So
No.
there's a risk there that this is something that would be problematic, is currently problematic, and will continue to be problematic after June 1st of 2025. And as you've seen from the statistics that we've showed you, what is online is the bulk of the complaints that are filed with the OQLF. Now, a question that is excellent. So how does the regulation, or how will the regulation address the label on a bottle that is inside a box on a store shelf? Is there any exception for small labels like drug products that don't have a lot of space for French and English? So this is an argument that's been made. We haven't heard the argument of the small space. We haven't heard anything that seems to suggest that there will be any exception for small labels, such as for pharmaceutical products. So, but we'll have to wait and see for the regulation, if it's going to address that and if it's going to provide any exception. I don't expect that. I haven't heard anything that suggests that, but we will have to wait and see. Now, a label on a bottle inside a box, expect that 51.1 will apply to the box and to the label on the bottle inside the box. That is perhaps the approach the, I would say, conservative and safe approach that you should take until we do get the further guidance from the legislation. Let me see here. Products that are sold over the counter, as far as we're concerned, same thing as for
Makes no
everything
difference.
else. Absolutely. So if it's a product that's sold over the counter, for example, in a drugstore, same rules apply. It's going to be in French. And if there's a trademark displayed on it, then you can, claim the trademark exception if you have a registration. That's how it's going to be most likely going forward. I have another question here. So, somebody is asking me about online marketplaces, such as those that commercialize products in the province of Quebec. Are those, one, subjected to the Charter of the French language, and two, assuming they are, which I believe you've confirmed, Francesca, before, then the products that are available on those websites, do they need to be displayed and to be compliant with the French Charter? And I believe that the answer is yes.
Well, if the product can be purchased on these type of marketplace site and be received in Quebec, the product would have to be compliant with the French Charter.
Thank you. So somebody is taking our example and transferring in another universe, and they're saying, let's say your registered trademark is Aphrodite Celestial Coffee. That sounds pretty good. And it's on a bag of coffee that is available for sale in a store in Quebec. So the question is, would the mark on the coffee need to appear as of Aphrodite Celestial Coffee in package? So first of all, here, I think that is there anything that would need to be translated in this trademark? So that's question number one.
If it's registered as a whole as a trademark, coffee for sure. Coffee for sure would need to be translated into French.
And I would beg to differ, and I would argue that I'm not so sure. So you see, we have fun internally, and that's why regulations are necessary. The example that was provided during the debate of the commission included, as was mentioned before, soft soap. Soap is what's in the bottle, and Jolin Barrette at the time said clearly, no need to translate this. If the brand is Aphrodite Celestial Coffee, do we need to translate coffee?
Well, it depends on how it would appear as a trademark as a whole.
Well, so that's another question that we have in that question that I was going to get to. So technically speaking, if you look at this from a trademark perspective, you would say, well, coffee is what's in the bag. It's generic. It needs to be translated. We're only going to find out the, sure answer to that question when we get the actual regulations. Until then, we're not 100% sure. Now, the other question is, will the assessment vary depending on how my brand is displayed? And that seems to go to your comment, Francesca. Yeah. If I put Aphrodite super big with Celestial, and then coffee is separated from it and almost looks like it's the name of the product, and do I have a problem? Well, as I said before, the folks at the OQLF are not trademark trained. And so if you show them a certificate of registration for Aphrodite Celestial Coffee, I think it makes the debate moot to a certain extent. Yes, it can give rise to an objection, but I think it would make the debate moot unless it's captured by the regulations that we're going to get under 51.1. Now, someone is asking us, is Bill 96 applied to federally regulated entities? I believe we've answered that question. The answer is yes. Commercial publications, what is that, Francesca? Can you provide a quick answer to that? And that will be our last question today.
Apart from websites, social media pages, as we have said, so any catalogs, flyers, and documentation of the same type, printed or available online, would be considered as a commercial publication.
Thank you, Francesca. So I think that takes us to the end of our presentation today. Thank you so much for all those questions. We know that this is a topic that is of interest to you. Stay tuned. If there are any developments, we will make sure to communicate them to you by way of a publication on our website. Also, please complete the questionnaire evaluation form at the end, so that we know if this is something that was of interest to you and what you would like to hear going forward. So have a great rest of the day, and thank you for being with us today.
Thank you.